For those of you who don't understand, ladies and gentlemen, ladies and gents, everything that goes on in the background when I'm doing a video, we're going to start off with a little bit of New Edition talking about Still in Love. We're going to show y'all this little document right here. Okay? And for y'all to know, this is an Intel Core i7. Okay? It is a 2.4 gigahertz computer, 16 gigabytes worth of RAM. Alright, and not just any RAM. And we ain't even gonna talk about the graphics. This is one of them so-called, I wasn't supposed to shut that off. Wasn't supposed to close that. That was impotent what I was doing. I'll do it later tonight. Alright, anyway, all of the things that I'm doing on this computer, all of the work that goes through with this computer, with what I do, I was able to get something that gave me the capacity to do that. However, because I stay connected to the internet, sometimes the little wonderful wannabes have their little agents go into my computer and they don't cause a lot of damage, but they do a little havoc. And that's okay, I don't mind that. And so I just redid the computer. However, I made the mistake, didn't know that what you can't do when you redo your computer with Microsoft Windows and it saves it in Windows Old, the Windows Old folder. I did not know that if you literally just take the file, drag and drop them into the current drive, the current Windows installation drive, that if you do it more than once, it will overwrite the folder without asking you, do you want to overwrite it? So I overwritten at least 500 gigabytes worth of data and files that I just worked on, so I had to start all over again. But y'all didn't come here to listen to all that, did you? We're going to open up this document. This is the Credit River information regarding the Credit River decision. Ladies and gentlemen, I told you that Credit River is your avenue. Credit River is where we should be going, where we should be headed. I'm not going to change that. I'm going to tell you all that you should be focusing on Credit River. Credit River is your remedy. However, we're going to also show you what's been said by the courts and what's been said by some idiots. Okay? We're going to put that right there for now so it ain't in our way. And we'll keep adjusting it until I can feel comfortable putting it someplace where it won't cause any damage. Okay? Alright, ladies and gentlemen. On July 11, 1969, Justice C. Donald Peterson, acting for the Minnesota Supreme Court. See, he wasn't a Minnesota Supreme Court judge. He was just acting for the Minnesota Supreme Court. Directed Martin V. Mahoney, Justice of the Peace, of Credit River Township, Scotts County, Minnesota, and Jerome Daly, counsel for the plaintiff. That's right, Judge Mahoney was no fool. See, he could have gotten an attorney to represent him, but no, attorney, officer of the court, he couldn't trust them fools, so he got Daly. You guys are going to learn something, most of you who didn't know this stuff. We're going to break this down. Written by the court, so we're going to break this down. Supreme Court wrote this. He, Jerome Daly, counsel for the plaintiff, in an action brought by one Leo Zorn against one Roger D. Derrick and the Northwestern National Bank of Minneapolis. Wait, how? Oh, the bank was of Minneapolis, but they lent the money in Minnesota. Because I'm like, how Minnesota and any Minneapolis getting involved with each other? Well, anyway. To show cause why they should not be permanently restrained from further proceedings in the Justice Court. Yeah, basically, they were trying to silence these two individuals after the Credit River decision. Now, we will resolve the issue as to whether Credit River has been repealed or not. That's what this video is about. We will prove to you what's going on with that case. To show cause why they should not be permanently restrained from doing anything in the Justice of the Peace Court from that point forward. In addition, Justice Peterson ordered a stay of all further future proceedings before the Justice of the Peace pending final determination of the question raised by Northwestern National Bank's petition for writ of prohibition. All right. Daly decided to help someone out And when he decided, get out of here, nobody asked you to pop up. It's monitoring. You see, it says it's monitoring in the background. We're going to let it monitor, okay? We got a hall monitor. Well, anyway, Daley decided to help Mr. Zoran out. And that's a good thing because he just got a victory. He just proved something in court. So he and Judge Mahoney went on a little spree of helping people out with mortgages. Now, although the stay order from Justice Peterson was served on the Justice of the Peace and Daley on July 11, 1969, July 11th, 6 months later, well, 7 months later, they intentionally and deliberately disregarded it in this way. On July 14th, 1969, the Justice of the Peace, upon motion of Mr. Daley, entered finding of fact and conclusion of law and an order for judgment in favor of Zoran. In response to our order of August 12th, 1969, pay attention, the Supreme Court issued an order that lets you know Peterson wasn't a Supreme Court justice. But they make sure you understand, and everybody understands, that that order was issued as a representative of the Supreme Court. So it's just as good and as well as he was a Supreme Court justice. Even though he wasn't a Supreme Court justice, he was acting on behalf of the Supreme Court. The Supreme Court can do that if they're acting under their common law jurisdiction, because they can delegate their authority to another judge who is assigned under their authority. Okay, they can't delegate another court in their country, in the country, but they can delegate another official to act as a judicial officer. Because remember, Congress does not pick the judicial officers. The judicial branch does that. And elections. Okay, pay attention. Now remember, we're August 12th, directing the Justice of the Peace and Daley to show cause why they should not be held in constructive contempt of the Supreme Court of Minnesota for this conduct. Mr. Daley appeared personally on his own behalf before this court on August 21st. Pay attention, August 21st, it's important. He advised the court that he had been authorized to represent the Justice of the Peace in the proceedings, so that the Justice of the Peace did not get a failure to appear. After noting that he was making a special appearance, ladies and gentlemen, you can't make any appearance. Any appearance you make is submitting to the court's jurisdiction. Okay, just so you know. And this was an administrative proceeding. This was not a common law proceeding. They had a right to do administrative because he was an officer of the court. Mr. Daley, an attorney at law, admitted to practice in this state, acknowledged that both he and the Justice of the Peace intentionally violated the order of Justice Peterson because, in their opinion, neither this court nor Justice Peterson had jurisdiction to issue it. Ladies and gentlemen, the Supreme Court of the state could issue an order directing a court to stay all further proceedings, which is what they did. However, they did it through another judge, another justice who wasn't a Supreme Court justice. And they did it in that capacity. But however, a day later, although the death of Justice of the Peace on August 22nd, 1969, how tragic that was, that Mahoney would die the day after Mr. Daley spoke on his behalf. It appears they needed to have some type of a response so that they could say that he violated the order intentionally and deliberately. Pay attention, in order for there to be a crime, there must be intent. So notice what they say. He said, attorney at law, acknowledged that he and the Justice of the Peace intentionally violated the order. Must be intent. Okay, let's continue. Of this court, and that he be temporarily suspended from practicing law in this court or in the courts of this state effective October 1st, 1969. So it says that Jerome Daley has his actions were contemptuous. It is ordered that by this court that he be temporarily suspended. Now, Jerome Daley was subsequently disbarred. He was disbarred in 1971. See, Henry Jerome Daly, Minnesota case. Okay? In that decision, the court noted, respondents' persistence and continual attacks on the nation's monetary system can hardly be regarded as zealous advocacy or a good faith effort to test the validity of repeated decisions of courts of record. Did you see that? Decisions of courts of record. Excuse me? What courts of record? Anyway, for as found by the referee, because he was being disbarred, so he went before a referee and not before an actual judge. Up to the time of his findings and recommendations, respondent had avoided payment of any federal income tax for 1965 and subsequent years. What does this have to do with anything? This ain't got nothing to do with his disbarment. His disbarment was over the filing of those other cases. Hold on. On the asserted ground that he has not received gold or silver coin and therefore had no earnings that were taxable. Ladies and gentlemen, he was correct on that. But this wasn't about tax evasion. This wasn't a federal court. This was a state court. Also, he has taken personal advantage of the system he attacks by borrowing money from a bank to purchase lakeside property, only to subsequently defeat the bank's repossession after mortgage foreclosure by taking the position that the bank's extension of credit was unlawful. Excuse me, they didn't extend credit. They loaned him credit. They didn't extend their credit to him. They loaned him their credit. If they were extending it to him, that's a different thing. It can't be called a loan. Obligating him neither to pay the debt nor to surrender possession following expiration of the time to redeem. Now, as detailed in the referee's finding, we regard the tactics employed by the respondent in the unlawful detainer proceedings before the justice of the peace as not only unprofessional but reprehensible. Ladies and gentlemen, they are talking about the proceedings that was involving Credit River decision, the Jerome Daly case. They didn't appreciate that. But did you notice? They said they regarded the tactics employed by him in the unlawful detainer proceeding before the justice of the peace as not only unprofessional. Didn't say legal. They didn't say unlawful. They said unprofessional. Now, did you notice? I don't care about no new versions being available. The party's over. Hey, the party's over. It ain't over. All right, let's continue, ladies and gentlemen. They said that it was unprofessional, but not only unprofessional, but reprehensible. Why was it reprehensible? Well, let's do this. The misconduct found by the referee, they got him for misconduct. Because he brought the case before the justice of the peace, they found his conduct being unprofessional and a violation of the ethics code, yet they cannot pinpoint what the violation was. Pay attention. And determined by respondents' oral declaration before this court in violation of the canons of professional ethics reflects professional irresponsibility to such a degree as to render the respondent totally unfit to continue to discharge the duties of an attorney. Y'all. He can't do that anymore because he didn't do everything he was supposed to do. Pay attention. All proceedings in the Justice Court in the underlying matter were declared a nullity in Zorn versus Northwestern National Bank. Pay attention. The same happened in another case brought by Jerome Daly in Daly versus Savage State Bank, Minnesota. Ladies and gentlemen, pay attention. I want you to see what they did. They said all proceedings in the Justice Court in the underlying matter, the matter what Daly brought the case and won with the jury, were declared a nullity in Zorn versus Northwestern National Bank. Yes, it was declared a nullity in Zorn versus Northwestern National Bank, but it wasn't declared a nullity in that case. This is a completely separate matter. Was not the same case. They could not declare it a nullity in a different case. There is no provision of law for somebody to you to have your case today, and then all of a sudden, tomorrow, in somebody else's case that ain't got nothing to do with yours, they declare it a nullity. The only thing about Zorn is that Daly was representing Zorn. That's it. That's the only thing in that case. It had nothing to do with the property. It had nothing to do with the issues of the Daly case. So they weren't a nullity. By the way, the case has not been overturned. See, in order for you to overturn a case, you would have to directly overturn the case. You would have to reverse the judgment. You can't reverse the judgment. Pay attention. That was a common law jury trial. Go back and read the 7th Amendment. The 7th Amendment makes clear that any case heard at common law, tried by a common law jury, can never be overturned by any court, cannot be revisited or relooked at. So the court does not have the authority to declare it a nullity. That's why Justice Mahoney did his memorandum the way he did. We're going to talk about that memorandum in a second, because that memorandum is extremely, what's the word people like to use? Powerful. Extremely powerful. Let's continue.
These cases were recently decided in Sneed versus Chase Home Financial LLC 2007 in U.S. District Court, Lexus.
Okay, this is a California case. Minnesota is bringing up the California case. Pay attention.
The court noted the frivolous nature of the plaintiff's argument relying on these cases and went on to say,
pay attention.
Furthermore, the Minnesota case cited the plaintiffs are not only unreported, but that they have been vacated by the Minnesota Supreme Court in reported decisions.
You can't vacate a common law judgment unless the jury came to a conclusion that no reasonable jury could have come to based on the facts and the evidence presented before it. You cannot overturn. That has to go through the process. The appeals court, then the Supreme Court. Guess what? Didn't do that. They didn't follow their own procedures. Ladies and gentlemen, go back and look at this. As a matter of fact, pause the video. This will do you a world of good, because the next video we're going to be talking about the wonderful, wonderful, wonderful habeas corpus. Okay, and people using that regarding their homes. Now you're going to have to be technical with it, but we're going to give you my example and we're going to go from there. Okay, but look, it says this is what the federal district court said regarding these cases. Okay, you use these cases. I don't want you to use these cases. Use the actual Credit River case. Credit River case has not been overturned because they didn't have the authority. You cannot violate the Constitution. Any act of any court that violates the Constitution is a nullity in itself. Go back and look at the case law that talks about that. Okay, any act by any court, that's what the Justice of the Peace put in his memorandum. We'll talk about that in the next video. Look, notice what the district court.
The plaintiff is hereby admonished, she must not cite any decision under which Justice Martin Mahoney purported to question the validity of federal currency.
Excuse me, purported? Wait. She was admonished that she must not cite any decision? I'm sorry. This has got nothing to do with Justice Mahoney. Justice Mahoney didn't come to a decision. Y'all need to go back and take a look at the Credit River decision. That was by a jury, a common law jury. They tried the facts of the case. You're going to see it in the next video. I'm going to show it all to y'all. Okay? But anyway,
validity of the federal currency.
The case doesn't even talk about federal currency. I want you all to take a look at the case. It doesn't talk about federal currency, not one time.
Or the constitutionality of the Federal Reserve Act.
He doesn't even talk about the Federal Reserve Act. In that case, not one time does he mention anything about Federal Reserve Act. The jury didn't hear anything about the Federal Reserve Act, but pay attention.
Nor may she cite any opinion or decision as authoritative which no longer has authoritative status.
Ladies and gentlemen, the Credit River decision was decided. Pay attention. The Credit River decision was decided by a common law jury. That is the most authoritative status you can have. So what I'm suggesting to all of you, use the Credit River decision in your case. Get a certified copy of that decision, that common law decision. Attach it. Get a just send to Minnesota, tell them, hey, I want a certified copy. y'all gonna be giving revenue to that state. I want a certified copy of that credit river decision. Attach it to your document. Explain this is a common law decision. It is binding on the entire United States. And this is an authoritative document because it has the seal of the state of Minnesota, which carries the full faith and credit. Okay? Notice what the judge says here. I want you to pay attention. The plaintiff is hereby admonished. No, the plaintiff is ordered. No. The plaintiff is hereby admonished she must not cite. Must not? Why didn't she just say the plaintiff has cited cases that have no basis in bearing in law? They are not validated. They have not been reported. See, the court talks about something not being reported, not being in a court reporter. See, unreported. Excuse me? That's statutory. This was a common law case. You don't have to report a common law case. It doesn't have to go into a registry. See? Vacated by Supreme Court in reported decisions. You see, unreported, reported decisions. Pay attention. These were all statutory decisions. The Credit River case was heard by a common law jury. In their statutory capacity, the court has no authority over common law. Look at the 7th Amendment, people. Okay? Remember, the justice said that he was acting under that authority when he had that Credit River trial. Okay? They never challenged him and said he couldn't act under that. They just said they couldn't challenge the constitutionality of the federal currency and the Federal Reserve Act. When you look at the next video, you'll see that there was nothing about federal currency ever mentioned in the Credit River decision. Ever. Okay. Let's take this, ladies and gentlemen. Martin Vincent Mahoney was born in Minnesota on February 22nd, 1915. Ladies and gentlemen, this is right after the beginning of World War I. And he died August 22nd, 1969, Vietnam War. Not in the Vietnam War, but during the Vietnam War. In Scotts County, Minnesota, Jerome Daley was born July 11th, 1926. Well, look at that. They weren't even that far from each other. Look at that. Do you see that? He was only 11 years older. Anyway, in Minnesota, and he died on March 23rd, 1996. Okay? In Martinez, California. Here's the reason why Justice Mahoney died August 22nd, 1969, and not August 22nd, 1989. Because a lot of you won't pick up on this. I didn't know this until I read this today. Hold on. We're going to go back to where the court speaks about Daley coming in and speaking on behalf of Mahoney because he had the authority to do so. So give me 1 second. Where? Yeah. There it is, right there. Y'all see it. Mr. Daley, an attorney at law admitted to practice law in this state, acknowledged that both he and Justice of the Peace intentionally violated the orders of Justice Patterson because in their opinion, neither this court nor Justice Patterson had jurisdiction to issue it. Ladies and gentlemen, hold on. If they're acting in common law, the courts do have jurisdiction if they're operating under common law. But because both of these individuals were officers of the court, that's why they highlighted this. Pay attention. An attorney at law admitted to practice in the state that he and the Justice of the Peace, another officer of the court, intentionally violated their superior's order. So they acted without lawful authority is what they're saying. So anything that happened after this was unlawful. However, the decision in Credit River still stands. Why? Because it was a competent jury. But pay attention. August 21st is when Daley shows up in court. They say he acknowledged acting as a representative for the justice, see, authorized to represent the Justice of the Peace in the proceedings. So he admitted that they violated the court order intentionally. That's all they needed. You see, if Mahoney had died several weeks before that meeting, even a day before that meeting, they couldn't make a determination based on him because they need his word. They need him to testify. If he doesn't testify, then they don't have the ability of using that against him. But if they had let this continue, if he had lived past the 22nd, because remember, he dies the next day. After they meet on August 24th, Mahoney dies the next day. If he had lived 5, 6, 7 years later, if they had removed him from being justice of the peace, you know he would have fought it. And he would have said that they were retaliating against him because he made a lawful decision. He didn't make the decision in the Credit River case. He made the lawful decision to handle other cases coming in that dealt with the same nature. The jury made the decision. The court didn't have the authority of overturning that decision. You hear them say it all the time. The only way they can overturn a decision made by a jury is if the jury came to that conclusion and no reasonable man or woman could have come to that conclusion based upon the information presented to it. That has always been the case with juries. It carries over to common law as well as administrative law. So, ladies and gentlemen, we're going to put this one on pause because I'll start that one on the next video. Anywho, this is just to give you guys the information so that you'll know what went on in that case. And when you ask the question whether or not Credit River is still binding, you have to bring up that this was a common law decision made by a common law jury in an actual common law court of the United States. No court can overturn this decision. Then you attach the 7th Amendment because, as we're going to explain, the Credit River decision was done under the federal Constitution, the 7th Amendment. The judge even says it in his memorandum, says it throughout everything that you read about what he wrote. He operated under the Constitution. Okay, and the courts never said he didn't have the authority to do so. What they said is that what he was doing was affecting the monetary system of the United States. Yes, because they were revealing the secrets. That it's not that they create money out of thin air, even though they do say that in the case. It's that they create credit. Credit is not money, people. That is not money. Money is defined by the Constitution. Y'all need to go read it again. It says nothing in there about credit other than the full faith in credit. Something being backed by the full faith in credit. Well, the credit created by the Federal Reserve cannot be backed by the full faith and credit of the United States. So if they're creating that credit, they must have something to back that credit with. They do not. And, oh, sorry, let me show y'all something. Let me show you something! Okay? Because y'all need to understand. And I'm going to do the best I can to help y'all understand. Y'all ready? I'm ready! Okay. Hey. Where's my mouse? I see my mouse on the screen, but I'm looking for where the cursor is so I can start doing this right here. Uh-oh. I don't know where it is, y'all. Let's do this. Okay, I guess it wouldn't let me do it. Okay. It ain't letting me do it. It ain't letting me click. Okay, let's do... Give me 1 second. This was the other case. The sheriff's cell above described is null and void. Yeah, this is the actual Mahoney case. This is where he says a 10-day stay is granted. That's for them to file an appeal. The defendant is awarded the cost in a sum of $75 and is hereby issued therefore. And Minnesota Constitution, repugnant to the Constitution of the United States, Bill of Rights, and so on and so forth. He does that to protect himself. We're going to talk about that. This is from that decision, but it won't let me do this, ladies and gentlemen. It won't let me type in what I need to type in, so let's do that. Yeah, it's not letting me do nothing on this particular page. So let's see if I can... Yeah, let's open... Oh, I see why. That's my fault. I didn't open this up correctly. I need to open this up in edit form. Sitting up here trying to type. No wonder it wasn't letting me type. Alright. Okay. Now I want y'all to see this. Aren't you glad you waited till the end of this video? I promise you, everybody who cut this off before will not get this. This is how you win your case with the Credit River decision. In the Credit River decision, the bank testified. The Federal Reserve Bank. Notice how when you read it, you'll see the judge said a Federal Reserve agent testified that they do not lend money. They only lend their credit, not extended. They lend their credit to people. And then those people agree to pay back. And because they make payments, they're somehow obligated to continue to make payments. However, you get them for violation of the Truth in Lending Act, because the banks will say that they loaned me for my house $150,689 and no cents.
That's right, you ain't got no sense, brother.
Anyway, this is what the banks will say. They will use this symbol right here. Ladies and gentlemen, what does that symbol stand for? Is this not the symbol of the American dollar? That is not the symbol for credit. The banks say they loaned you this. They loaned you dollars. The bank's credit, or their bookkeeping entry credit lending, is not dollars. Go ahead and look up the definition. Well, because they didn't loan you dollars, the contract said they loaned you dollars. I'm still waiting on the dollars, because that was the agreement. They were going to pay me dollars. They were going to loan me dollars. They haven't loaned me dollars. They only loaned me credit. I'm still waiting on my dollars. Some of you are really going to understand what I just said. And you take a certified copy of the Credit River decision, where you get the fact that pay attention, watch the next video, where the individual spoke on behalf of the Federal Reserve Bank as a representative of the Federal Reserve. And by doing so, he documented the fact on record, which has been unrebutted to this day. Nothing in the Credit River decision has ever been rebutted. Okay, they just didn't like the fact that that information came out on record and they couldn't control it. That's what the issue was. So, I'm going to leave y'all to be. Just want to show y'all, your mortgage uses this symbol. Don't believe me? Go take a look. It says you agree to pay that back. You can't pay that back. They didn't give it to you. You can only pay back that what you gave. Remember, there must be consideration. They didn't give you no consideration. They did not give you any consideration. There must be consideration. Well, ladies and gentlemen, ladies and gents, the next video we're going to go into detail about how a habeas corpus is going to be used to try to save a home. Pay attention. You might find it interesting.
Goodbye.